Okay, and we are live. So you're onboarding a new employee, you're balancing a ton of paperwork, you got through the I-9 process smoothly, and now you've started a case with E-Verify, and suddenly you've been issued a tentative non-confirmation notice or a TNC notice from E-Verify. And that's another thing that's been added to your plate. So what do you do as an HR professional? My name is Emily Brown, and I'm the founder and principal attorney of Elevate Justice U.S. Immigration Law. We're a private law firm that specializes in immigration compliance and federal litigation. And welcome back to our Wednesday Lives Immigration Compliance Corner, where we talk about all things immigration compliance from I-9 and E-Verify compliance to also visa program compliance as well. Before we get started, everything that I'm sharing today is general educational information only. It is not legal advice. Immigration law changes frequently. So for guidance tailored to your business, consult a qualified immigration attorney. So today's topic in Immigration Compliance Corner is E-Verify. Just a quick refresher in how to handle a TNC notice, a tentative non-confirmation. This is really the tip of the iceberg with E-Verify compliance, but I wanted to spend some time going through it to remind folks some of the different nuances that are involved. So if you are an employer that uses E-Verify, you would know that E-Verify is a process that is completely separate from the I-9 process. It does not replace the I-9. It does not replace the employer's obligation to verify the proper work authorization documents when completing Section 2 of the I-9. It is separate and a whole thing in and of itself. So after you complete the I-9 with your new employee, you're going to then open a case with E-Verify. And when you create a case, if the employee's information that they've given you doesn't match what's in the government, what you can receive is a TNC, a tentative non-confirmation notice. And usually it's checking the information against DHS databases like USCIS or the SSA, the Social Security Administration. So if there is information that is conflicting with the information that was in the E-Verify case for that employee, you're going to receive a TNC. So for DHS, you might get, so a TNC, just to backtrack a few seconds, a TNC is essentially saying that the information is a mismatch. So oftentimes a TNC can be referred to as a mismatch notice as well. So you could receive a mismatch notice or a TNC based off of a DHS mismatch if the employee's A number, their name, their I-94 number, or their passport number isn't matching with the information that DHS has. If the passport or passport card information could not be verified, if the information was not updated in DHS records, so for example, their citizenship or their immigration status changed, maybe the record contains some type of error on the DHS side, or also if the employee didn't give you the right information, maybe they accidentally messed up one of the numbers, or if the employer, when they created the E-Verify record, didn't put in the correct information, because there is human error. There could be typos in there. Again, so now for the SSA, the Social Security Administration, there could be a mismatch if the citizenship or immigration status was not updated with the Social Security Administration. So a lot of times people on immigration status don't realize that once they become a US citizen, they have to actually go and update their status with the SSA. So sometimes they miss that step and it could result in an SSA mismatch. Maybe also the employee didn't report a name change to the SSA, so that could cause it, or the information is just not matching their name, social security number, their date of birth. And again, we could have those human error cases as well, or maybe the number that the employee gave you was accidentally wrong, or the employer accidentally put in the wrong information into E-Verify. So what do you do if you receive a TNC for your employee? The employer is required to notify the employee of the TNC and provide them a copy within 10 business days of receiving the TNC. It's really recommended, though, to do it right away so that the employee has as much time as possible to determine what they're going to do and take appropriate steps if that's what they decide to do. So 10 business days, 10 federal business days, because federal holidays are not calculated inside of that. But you really should let the employee know as soon as possible and give them the notice. You're also going to review the notice. You want to double check that the employee's information on the notice is correct. It's what the employee actually gave you. And then when you give the notice to the employee, you want them to also confirm it as well. Like, is this actually the correct information? So you want to make sure, like, that's the first thing. That could be a really easy fix if the information was accidentally entered wrong. So double check that the information is correct. After that, the employee then has the choice whether to either try to resolve the mismatch or they can actually decline to do so. So if the employee does decide to contest the mismatch or to try to correct the information with the relevant government agency, they actually need to be the one to contact the government agency. And the TNC notice is going to tell them how to do that for whichever agency is the one that reported the mismatch. The employee has 8 business days to make that contact, to contact the government agency to either update their information or provide corrected information. The deadline should be, also, so when the employee decides that they're going to challenge the mismatch or to try to correct the information for the mismatch, the employer then goes back into E-Verify and they hit continue in E-Verify, and it's going to say that the case has been referred, because then it's going to be referred to the government agency for the process to correct the mismatch. Once it is referred, you're going to get a notice from E-Verify, and that will also have the deadline for the employee to contact that agency. So you want to give the employee a copy of that. So that referral notice is going to say, the TNC is going to tell the employee how to contact the agency. If that's what they decide to do and they tell you that's what they decide to do, you put the case in E-Verify into referred. It gives them another notice that tells them the deadline. And that deadline is going to be 8 federal business days from when the TNC notice was issued. Now, if the employee declines to take action with the TNC within the time period, or they don't respond, the employer may close the case and E-Verify after 10 business days from when the TNC was issued. But what's really important is that during those 10 business days, while the employee is trying to decide what to do, the employer is not allowed to take any adverse action against that employee. That could lead to civil or criminal liability for wrongful employment actions. So once the TNC is issued, there's 10 full business days where you are not allowed as the employer to take an adverse action against that employee. If the employee decides to contest it, they are allowed to do so within 8 business days. That's when you change the status to referred and E-Verify. If they don't respond to your attempt to contact them and provide information, or if they decide not to challenge the TNC or to try to correct the information, after that 10 business days, the employer is allowed to then terminate the employee without civil or criminal liability. So when the employee contacts the agency, the response that will come from the federal government is going to come up in a few ways. So once the employee contacts the relevant agency that's reporting the mismatch, the federal government then has 10 business days on their end to correct the record or update the information. After those 10 business days, there's generally a few things that could happen. So they could come back and say, okay, the employment has been authorized, the mismatch was resolved, and there's no further action needed. The status could change to E-Verify needs more time, and that means DHS needs more time, and they encourage the employer to check back in 3 business days. Case in continuance means the employee has contacted the agency, but that the agency needs more time to review. It could take quite a bit of time, sometimes maybe even up to like 60 to 120 days. So if it's in case in continuance, what's really important to understand is that extends the period of like when you cannot take adverse actions against the employee. So definitely a key there. They could close the case and then ask for it to be resubmitted. So DHS or SSA needs the case closed and a new case submitted with the correct information. And then lastly, there could be a final non-confirmation, an FNC, which means the mismatch was not resolved. And if there's an FNC issue where the mismatch is not resolved, the employment authorization has not been verified, the employer is then allowed to take the steps to terminate that employee. So just again to cover quickly what the employers cannot do during the TNC process, employers cannot terminate them. the employee going through the TNC process. The employer cannot suspend the employee. They cannot alter training schedules. They cannot withhold pay, and employers cannot restrict work assignments or anything else that could be construed as an adverse employment action. So again, like I said, this is the tip of the iceberg with E-Verify compliance. I am hosting the HR I-9 compliance cohort starting on June 23rd. Space is still available, so I'll drop the information in the comments if you're interested in signing up. But we're going to do a deep dive into E-Verify compliance, all the different nuances, go over some practice cases of some scenarios that might come up that actually might trip up HR professionals. So if you're interested in joining us, definitely check out the link in the comment. But I hope you found this information helpful. Again, my name is Emily Brown, founder and principal attorney of Elevate Justice U.S. Immigration Law, and I will see you next week for our Wednesday live Immigration Compliance Corner. Have a great week, everybody.